Yes, I hope you guys can hear me and you guys can see me as well. This is Advocate Amey Hadwale. I am a partner in ANG Associates, a law firm which is based in Bombay. I am mainly into commercial litigation and my core forte is insolvency bankruptcy code. I have been practicing in NCLT since quite a few years and I have a fair amount of exposure in dealing with IBC cases. So I hope you guys are doing well. And I would have otherwise liked to have an interactive session, a live session, but due to this format, we'll have to do it as a recorded video. Nevertheless, uh, the today's subject in that sense is drafting of insolvency petition, and the second subject is drafting of a liquidation application. I would prefer in that sense to take both these subjects in the same seminar because I don't think so. It's a very lengthy subject. So let's go about it. Generally, in relation to IBC, we have our barracks in our hand, but when you are on your iPad or on your laptop or mobile, this is one website that I prefer using because this is a very good website in that sense. They constantly and very promptly update all of those amendments that the IBC and the IBBI puts into the regulations, and it's a very structured website. So you guys can also use it well whenever you are referring to IBC code. So, before starting with the main subject, I am sure that other faculties must have given you a deep insight about how IBC, what was the background of IBC, how IBC was, how did IBC came into existence, what was the need of IBC coming into existence, and then how the IBC has done so far. I would not dwell much upon those aspects, but I generally prefer to give a 5-7 minutes of background in that sense in my version so that things are in link. Uh, to begin with, India as a country, the problem with India as a country was in economic terms. As you know, that in every country, its economic reforms, economic management is the backbone of the country. So, but in India, in somewhere in 2000, somewhere in late 90s, the difficulty that the government was facing was of increasing NPS. NPS, as you guys know, non-performing assets. So there was frequent non-performing assets that were increasing day by day. The government was facing hardships. The banks were facing hardships to recovering these non-performing assets, and the government was facing difficulties in reducing these non-performing assets. So there was a requirement of a robust system to be put into place so that things are controlled. Otherwise, if the NPS goes on increasing, and if the banks or the financial institutions lose confidence in lending money, the credit worthiness will be finished, and and that would adversely affect the economic system entirely. Therefore, it was a need that the NPAs are reduced and there was some system in place where things would be taken care of. Therefore, in early 90s, the government started in the late 90s, obviously, the government started with a reform. Previously, if supposingly the bank has given a loan to some company or any institution, the only and the institution as the company has defaulted in making repayments of that loan, and the loan account has turned bad. It's turned as NPA. The only recovery tool that the bank could have is filing a civil suit, and we all know as law students, there are some limitations to civil suits and how prolonged litigation as it takes for a civil suit to come to a conclusive end. Even after we obtain a decree, execution also it takes its own time. So banks, from the account being turned as an NPA till the bank could recover something, there has to be a fair amount of 8 to 10 years of prolonged time that the bank would suffer. This shattered confidence of the banks, and the banks were not very confident to lend loans in that segment. So there needed a system which gives some power to the banks so that the banks could recover the loan fast. So there were two parallel segments which were running side by side. One in terms of resolution. company resolution of the company or the corporate sector, the government introduced a act called Sikh Industrial Establishment Act. So it was called as SICA. So and parallelly, the government also introduced an act called RDDB Act. Under RDDB Act, the DRT tribunals, debt recovery tribunals, were constituted. The main objective of SICA, if I may say, was to reorganize, or in that sense reform the Sikh industrial unit. But as we all know that SICA didn't work out well because of its own shortcomings. So as to say that the major flaws with SICA were that SICA did not see the main definition of a Sikh industrial unit in that sense was there was a fundamental problem with SICA, that the definition where Sikh industrial unit would have been classified as Sikh is when the accumulated losses of the company is more than the net worth, the company would have known as Sikh industrial unit. And after the company is declared as Sikh, someone would have made a reference to BIFR, that was a tribunal constituted under Sikh industrial unit. Again, after making a reference to BIFR, regular creditors could not make reference to BIFR. It was only the state undertakings and banks and the company itself, along with its promoters, could make reference. So all the creditors were completely outsided from this SICA Act. After the reference being made to BIFR, there was no time constraint within which the BIFR was required to conclude the proceedings. So that was one major factor. So considering all of these drawbacks, SICA didn't work out really well and did not achieve the objective that SICA wanted to. Uh, therefore, SICA was limited to its constraint. Simultaneously, on the other leg, RDDB Act was initiated, where the banks could file an OA, original application, before DRT to obtain a recovery certificate from DRT, and then after obtaining the recovery certificate, they could execute that recovery certificate. But the pendency of OA and the limited infrastructure that DRT had, the RDDB Act also did not work out very well. Therefore, somewhere in 2000, early 2000s, the government understood that we need to have some robust system with less intervention of courts, so that the bank can immediately liquidate its secure assets as far as secure loans are concerned. So an act called SURFACE Act was introduced in 2002, and in the SURFACE Act, a power was given to the banks with very less intervention of the courts, that if the bank has lent any secured loan, and if the loan has turned bad, the bank had an option to recall the entire loan after the 90 days of the loan turning NPA under Section 13(2) of the SURFACE Act, where the bank would only give 60 days for the person to make a repayment of the entire loan. If that company or the person, if the company fails to repay the loan in the 60 days, the bank would then send a loan notice under Section 13(4), get an order of Section 14 from the magistrate. That would take a very less time, that is 3 or 4 months. And after the order of under Section 14 is the bank has got, the bank could simply go and take control over the secured asset, whatever the security the company must have provided, and then proceed to sell that security, liquidate that security. Now, this was SURFACE Act, where complete power was given to the bank, and the bank could realize its bad loans by enforcing the security interest with minimum intervention of the court. This act by far it achieved its objectives, and quite drastically the NPA reduced, and it was going well. But there was short problem with this act, if I may say. The act was very brutal. It typically focused on recovery of the loans. It gave no heed to rehabilitate the company, or in that sense take care of any resolution of the company. The bank would simply go and attach the assets and sell the company off. It would never think what would happen to the employees, what would happen to the business of the company, the brand value, everything, and all of that was never given a consideration of. Uh, Therefore, there was a need of a reform as to where the priority should have been given to resolution of the company rather than just the recovery. Therefore, in 2016, SICA was repealed because of its ineffectiveness, and IBC was promulgated. The uh, the object of IBC, or rather I would say the heart of IBC, was to maximize the value of assets, to provide resolution of the company, and to allow the creditors to recover their amounts. The intention was never singular to only recover the amounts from the creditors. The primary intention was also to provide resolution of the company, so that the all employees and the brand value and all of those efforts which have been put for the company is never wasted. So then 2016 IBC was promulgated, and this act was in that sense called a Creditors Act. Therefore, where the creditors were in charge of the were put in control. Earlier, the threshold limit of IBC, as you guys know, was 1 lakh. Now the threshold limit is after during the COVID times have been increased to 1 crore rupees. So for a creditor, for a company who has so IBC was applicable only to companies and partner LLPs. Individual insolvencies was not notified. Today also individual insolvencies are not notified. Only personal guarantee insolvencies are notified. So filing an app to initiate, for example, now supposingly a company has defaulted has taken a loan from the bank and has defaulted in making repayments of that loan uh, to the tune of considering today's situation for 1 crore rupees and more. The bank would simply file an application under Section 7 of the IBC to NCLT, and the NCLT would then consider the application. The NCLT had a very limited scope to consider the application. The NCLT would only say whether there is a debt, that is primary requisite number 1 for a Section 7 application, and second, there is a default. These two things are something which are essential for NCLTs to see under a Section 7 application. If both of these ingredients are satisfied, the NCLT would admit the application under Section 7 and initiate corporate insolvency resolution process. In short, we call it as CIRP. The NCLT would initiate CIRP against the company, and the CIRP will have its own necessary consequences. I'm sure the other faculties must have taken you about in depth about what CIRP in that sense is. The consequences, for if I may state, is the powers of the directors were suspended, or the resolution professional would have been will be appointed, and the moratorium will be kicked in. All of these consequences arises after the initiation of CIRP. Today, sticking to this subject is we are really concerned with the drafting part of the filing of the application for admission of insolvency. So, as you all guys know, that the threshold for filing an application under Section 7, 9, and 10, there are three sections under which an application for initiating insolvency against a company or an LLP can be filed. So, Section 7 is filed by the financial institution generally, or any of the company, but it is relating to a financial debt. So if a company owns a creditor a financial debt is in that sense a loan or something, then the creditor who owes the creditor to whom who has given the loan will file if there is a default in that sense, will file an application under Section 7 for initiating insolvency. Similarly, under Section 9, speaking about Section 9, if the company has availed any goods and services from the company, the company has availed any goods and services from from any entity, and the company has failed to make repayment about that goods and services, and more or less there is no dispute in relation to the goods and services that are availed, and the debt is very well acknowledged, the creditor, and there is a default in making repayment of that debt, the creditor can very well approach NCLT and ask NCLT to initiate corporate insolvency resolution process. That is under Section 10. Section 9. Third option to initiate insolvency is Section 10. Section 10 is a situation where the company itself or the directors of the company itself feels that now we are not able to manage the affairs, or in that sense no more solvent, and we are not able to repay our debts, and there is a default that we have done for a debt which is more than 1 crore. That can be a financial debt or an operational debt. So they suo moto themselves after passing necessary resolutions, go to NCLT and say and file a Section 10 application, provide all of those documents that are required, and say that okay, we have defaulted in making payments. Now we don't think we would be able to manage these affairs. Now please appoint an RP and please initiate corporate insolvency resolution process in respect of this company. Now we are in the first session of this seminar. We'll really focus on how do you file an application under section 7, 9 and 10, and what are the key ingredients that you have to focus while drafting these applications under section 7, 9 and 10. So first of all, if you see, this is a preliminary chapter 1 of IBC deals with preliminary sections. Those are 4 and 5. 4 and 5. Chapter 2 of IBC deals with sections 6 to 32. These are mainly corporate insolvency resolution process sections. So we are concerned with this. So let's enter here. Chapter 2. Chapter 2, section 7. We'll go with section 6 first. Persons who may initiate corporate insolvency resolution process wherein a corporate debtor commits a default of financial creditor or operational creditor of the corporate debtor, as I said, itself may initiate corporate insolvency resolution process in respect of the corporate debtor as provided in the code. That's fine. We have all understood this now. Now coming to section 7. Section 7, I said, can only be filed by the financial creditor. So a financial creditor either by itself or jointly. So a creditor can singularly file or can also jointly file the application along with other creditors or other persons on behalf of the financial creditors as may be notified by the central government may file an application. So this is an application which has to be filed for initiating a corporate insolvency resolution process against the corporate debtor before adjudicating authority when the default has occurred. Okay. Provided that financial creditors refer to A and B, subsection 6A of the application initiating insolvency resolution process against the corporator shall be filed jointly and not less than 100 of such creditors in the same class or not less than 10%. So this proviso really deals with real estate projects wherein allotee. Now if you see section 6A of subsection 6A of section 21, you will know this section speaks about allottees. When a real estate company has been put into insolvency by the home buyers or rather by the allottees. So a single home buyer or an allottee cannot file an application under section 7. That section 7 application has some eligibility criteria that has to be fulfilled. What is that eligibility criteria? That is, their application should be accompanied by not less than 100 of such creditors, those are allottees, or not less than 10% of the total number of the creditors of the same class. So for example, if a real estate project has 100 allottees, the strength of the project is an 100 allottee project, 100 flats are made by the developer, so that application has to be filed by not less than 10 creditors. So 10 or more creditors will only file that application. If it's filed by nine creditors jointly, then that application would not be maintainable. So supposing, or in that sense, if a project has 2000 flats, so in case of 2000 flats, 10% comes down to 200. But however, there is one number, 100 numbers prescribed. So whichever is less, it says. Wow. So in case of 2000 flats, 100 of such creditors together coming and file an application under section 7. Okay. So we are really very concerned with the applications. Those are normally filed by banks and the individual creditors. Those are regular applications. So now if you see this section, it says again, a financial creditor either by itself or jointly with other financial creditors or any other person on behalf of the financial creditors as may be notified by the central government file an application. Now this application which is required to be filed is governed and in that sense there is a particular format that has been given in respect of this application. So that format is given in Rule 10 of Insolvency Bankruptcy Application of Adjudicating Rules. This is a separate rules which are provided by NCLTs, which gives the format of section 7 applications. Okay. So now I have separately opened that adjudicating rules the tab. This you guys can see here, the insolvency and bankruptcy application to adjudicating rules here. There are certain rules which NCLT has. So there are, as you guys know, IBC as an act is introduced by the parliament. It comes from parliament. Under the IBC Act, there is a regulatory authority which is to be constituted. That regulatory authority is called as IBBI. IBBI comes out with certain regulations to fill up the gaps which are there in the Act. Those are generally procedural regulations. And the third vehicle is NCLT under the IBC Act, as there is an IBBI regulatory mechanism provided for constitution of IBBI, there is an adjudicating authority which is called as NCLT. Similarly, NCLT has also been given its powers to prescribe its rules. Those are called as NCLT rules. So now these rules are being prescribed. So these rules will have its own definitions and everything. Now, if you see an application by a financial creditor, it is provided in Rule 4 of Insolvency Application to Adjudicating Authority Rules. Let's open Rule 4. Rule 4 says a financial creditor either by joint itself or jointly shall make an application for initiating corporate insolvency resolution process under Section 7 in Form 1 and accompanied with the required documents and record. So this Form 1 is really the format which the IBBI has prescribed, under which you have to file an application under Section 7. This is a specimen format of Form 1. This is Form 1, application by financial creditor to NCLT, application to initiate corporate insolvency. This is Part 1. Part 1 is general details, name of the financial creditors, date of incorporation of the financial creditor, identification of the financial creditor, and so on and so forth, person authorized and so on and so forth. Part 2 is everything about the corporate debtor against which you have to file the application to initiate insolvency. Name of the corporator, identification of the corporator, date of incorporation, share capital, and details and all of those. Small. Part 3. Part 3 is so under Section 7, you have to mandatorily propose an interim resolution professional. In case if the application is admitted, this interim resolution professional will be appointed to take charge of the company. So you have to propose the name and details of it. So here there is a consent which has to be taken from interim resolution professional. His name has to be inserted here and a consent form has to be annexed. What is most important is Part 4. Now, Part 4 has two columns. One is total amount of debt granted and dates of disbursement. Here you have to mention what is the total amount of debt that was granted and the manner in which the amounts were disbursed. Point number 2 in Part 4 is amount claimed to be in default and the date on which the default occurred. Now these two things are very important in Part 4. Total amount of default would be your principal amount plus your interest amount. I will obviously show you a final Section 7 which we had already filed and it's got admitted after we have completed this. So amount of the claim, total amount of default would be principal amount plus the interest amount and the date on which the default occurs. You have to be very careful while you put the date of default. That date of default would really start your limitation period. As you know that filing an application under Section 7, 9 or 10, you have to file it in 3 years of the date of default. So the date of default is generally the date on which the first installment was defaulted, or you can also put an NPA date. NPA date is also recognized as defaulted by Supreme Court in various judgments. So these are date of defaults under Section 7. So supposingly the loan is a continuing loan and NPA was at a particular point of time, and after NPA the bank still continued to service that loan, and within 3 years they somehow decided to file an application under Section 7. In that case, NPA would be the date of default. So that this has to be very taken care of. Then Part 5. Part 5 are particulars of financial debt, documents and records evidencing the date of default. So particulars of security head, all the mortgage deeds, charge certificates and all of those documents where you show that this is a secured loan, all of those documents are to be attached and listed here. Particulars of an order of a court or tribunal. If you have if supposingly there is some decree by a civil court where your claim is already adjudicated or there is an order of any award in your favor, the bank's favor, the creditor's favor, that has to be attached. Record of default with the information utility. Now this information utility is set up by a third party called NSCL, where you have to get yourself notified. The creditor has to go to NSCL website, has to record the default that has been occurred by the creditor, by the company. The notification is sent to the company. The company has an option to acknowledge the default or to say nothing about it or to dispute. So this is an information. This is a separate third-party record which is created by an independent agency. So the creditor has to lodge his record of default before filing an application. After you have lodged that default, there is an acknowledgement by the utility. There are sets of forms that the utility provides that complete annexure has to be attached here. Then detail this has been recently introduced. I In the beginning it was not mandatory, but now it has been become mandatory. Then details of succession certificate. All of these are optional. So if you have it, you will have to annex it. If you don't have it, that's not a problem. Latest and complete copy of financial contracts. Record of default as available with credit information company. This is any default which credit or CIBIL or any other credit rating agency has recognized. That CIBIL report will have to annex here. Then this is banker's book evidence. As you know, 65B of Evidences Act, earlier Evidence Act, provided that every electronic copy has to be supported with a 65B evidence certificate. So that certificate has to be annexed. The bankers will have to provide their certificate and any other documents that you may provide to substantiate, to make out your case of default. That has to be attached here. Then this is an undertaking. And then the person who is authorized signatory of the financial creditor has to sign here and in the name in the block letters. These are some instructions which you'll have to take care of. Now, I'll take you to a Section 7 application which was filed by us, the format, and which was admitted by NCLT. What I showed to you was a Form 1. But when you file an application under Section 7 of NCLT, there is a specific format which NCLT has given that you will file in NCLT rules. This format is in such a manner. First, you will have the cost title. Cost title is in such manner. Here, Arshija Steels Private Limited was the financial creditor who had given a loan, and AGS Impex Private Limited was a corporate debtor who had availed the loan. There is an index. Index would have memo of parties first, synopsis, list of dates, then the Form 1 that I showed you right now, then the annexures, exhibits. These are the exhibits. After the exhibits are completed, there is this general affidavit verifying the petition. Then there is wakalatnama of the advocate, and then proof of service of filing the application, serving the application. If you scroll down, in the same sequence, your annexures are documents are attached. This is memo of parties. This is how it looks. Here you will have to put the name of the counsel who has filed this. Then this is synopsis. Synopsis are your storyline of the application as to how did you what happened and how did you how the loan was granted and how the default occurred. Synopsis generally should not be more than one or two pages at the max. Synopsis should be such that when the judge is reading the application, at one glance, say for that sense 30 seconds, by reading your first and second pages in a very concise manner, the judge should get a grip of the application as to what this application is all about. How was the loan given and how was it defaulted? Then there are list of dates. List of dates would start from the person making the application to the bank to grant a loan, and then there was sanction letter issued, and then disbursements happened, and then the default recall letter was issued, or if sufficient proceedings simultaneously. All of that events and list of dates and events are to be recorded here. After list of dates, actual Form 1 starts. Form 1 specific we had seen on that website. This is the actual Form 1 in this particular case. So this is to NCLT from the name of the creditor in the matter of so and so. Part 1, as I showed you, name of the financial creditor, date of incorporation, all of the details, basic details of financial creditors. Part 2, as I showed you, are the basic details of the corporate debtor. Part 3 is the details of the IRP, the interim resolution professional that you propose to appoint. And part 4 was, as I said, was very important. Part 4 is total amount of debt granted and dates of disbursement. Here the total amount of debt granted was 7 crore 79 lakhs all. Principal was 84 crores to towards principal, 7 crores 71 lakhs was principal, and 84 lakhs 79,000 towards interest component. And there is this the what we have put in the synopsis in a very detailed manner. You have to set out your case as to how the loan was sanctioned, was it granted, when what happened thereafter, and how was it defaulted. All of those storyline has to be put here. Any other documents which you have, for example, in this case, there was 26 AS certificate where the creditor had deducted, where the company, the corporate debtor had deducted TDS and deposited in the account of the creditor, and that was reflected in the 26 years of the creditor. So this is a acute acknowledgement of debt where interest was payable and the TDS was deducted. So this was one document that could that is attached here to show that the loan is that there is a loan which has to be repaid. So once you have made out a case here, second is amount of claim to be in default. This is the amount to be claimed in default. This is the principal amount and the interest amount and the date of default. So the date of default here is 30th 6 2021. In this case, there is a loan agreement. Generally, there are loan agreements in every cases. And this was a case where particularly a loan was given by one company to other company, and the debt was repayable. The loan was repayable on a particular date. So this is that date of default as provided under the loan agreement. So from this date, my date of limitation would start. Now one has to be very careful that under section 10A, if I should show you what is section 10A. Section 10A, as we know, the country suffered a COVID scenario during the period from 25th March 2022 and 25th March 2020, and most of the companies without any reason could not service their loans because there was no revenue happening. The economic situation was very bad. So the government decided that such companies genuinely who are doing good but due to unforeseen circumstances could not service the loan, they should not be put into insolvency by the banks. Therefore, they introduced section 10A. So what 10A says, notwithstanding anything contained under section 7, 9 or 10, no application for initiation of corporate insolvency resolution process of corporate debtor shall be filed for any default arising on or after 25th March 2020 for a period of 6 months or such further period not exceeding 1 year from the date of as may be notified on this behalf. So what did it effectively say? That any default, for example, any default done by any creditor in repayment of the loan after 26th March 2020 until 6 months, which was extended later on up to 1 year by the notification by central government. You will find the date of the notification. So effectively from 25th March 2020 to from 25th March 2020 to 1 year after that, that is 25th March 2021, any default that has been committed, for that default, no applications for insolvency against the company can be filed ever. Can never be filed. So if you see, I hope you are able to see the screen. Provided that no application shall ever be filed for initiation of corporate insolvency resolution process of the corporate debtor for the said default occurring during the said period. So while you're drafting the application and you're putting the date of default, you would have to see that your date of default, if any, was not during that period. If the default is occurred during that period, your applications for insolvency would not be admitted, would not be maintainable in that sense. And you will have to also see while putting the date of default that you are within the 3 year of limitation as of date of filing of the application from the date of default. And even if you are not within the 3 years from the date of limitation, supposing the date of default is of 2015, somewhere around 2015, but within every 2 years, the company has come back to the bank and given its acknowledgement, or the company in its balance sheet had acknowledged the loans that it owed to the bank. So therefore, every acknowledgement that the company gives you an extension of limitation period under section 18. So Supposing the date of default was 2015, you have an acknowledgement of 2017, then you again have an acknowledgement of 2019, again in 2022, 2021. Every two before finishing of before the end of 3 years, every interval you have an acknowledgement. Your application can be still maintainable because your limitation has time and again extended by that period. So that this is something that the candidate should be very cautious of while putting date of default. Similarly, this was an unsecured loan. So in this case, just a minute. Ah, In this case, there was no security that was held. But ideally, in cases of banks, there are certain mortgages created, charge certificates are there. All of those documents are to be attached here. Order of any tribunal not applicable. Record of default. As I said, this petition was filed way back in before some time. Therefore, at that point of time, the record of default was not required. Now it is required. Now you will have to notify to NSAL the record, the default, and you will have to get the acknowledgement receipts from there, and you will have to attach it here. Details of succession certificates not replicable. Now, latest and complete copy of financial contract. As I said, there was a loan agreement in this case, and a promissory note was also given. Therefore, financial contract is covered a loan agreement. So that is there. Record of default is available with any credit agency. In this case, it was not there. Banker's certificate, since this was not a bank, it was a creditor. This particular column was also not required. It was not applicable. And any other documents. So it's as mentioned above and attached. So the documents, if you see, are already attached in this particular uh, part 4 itself. If you see part 4, this is exhibit D1, E, F, G, H. So all of those documents are already attached to form 1. So therefore here we have said that all of those documents which are above attached. You may also reiterate the list of the documents again. That's completely upon you. That's only different ways of drafting. Then afterwards, the applicant hereby certifies to best of knowledge so and so is qualified to permitted to act as insolvency resolution professional. You have to give an undertaking. There is specific court fees which is prescribed. This 25,000 for a Section 7 application. The applicant submits that the honorable tribunal may please to admit this application. This is your prayer. Person authorized to file the application name is to be mentioned, and your board resolution or the bank, in case of a bank, the power of attorney or any document where the banker has given that particular person authority to file his application, and the document has to be attached. So this is basically a draft of Section 7, and later on there are exhibits that we had shown in the index. This is the format of the board resolution. In the case of the company, this is the format. In case of banks, there are different format. So these are those documents which I showed you above. Then, if you recollect in the index, I had shown you after all of those exhibits, there is an affidavit which has to be attached. So this is the stamp paper of that affidavit. This is affidavit. It is the format of affidavit is given in form number NCLT 16, rule 34 of NCLT rules. There is another set of rules which are called as NCLT rules that you will get this format. You will have to say that so and so person is the authorized representative, and all the statements that are made in part 4 and 5 of the form 5 are true and correct, and then the verification, and then the wakalatnama, and the person who has been appointed as an attorney, his name and details have to be provided. This is long and short of an application which is filed under Section 7. So people will have to take care about all of these things. Section 7 applications, to sum up, should show necessarily two things. As I said in the beginning, one is there is a debt. How would you show there is a debt? By showing that the bank has disbursed this amount to the accounts of the corporate debtor. The bank statements will sufficiently prove, the sanction letters will sufficiently prove that. Second ingredient that you have to satisfy in the tribunal is there is a debt and there is a default that has occurred. How would you prove the default? You would prove the default again by your bank statements, where the amount is shown as outstanding. You will prove the default by recall letters showing that you have sent a recall letter, supposingly a normal recall letter the bank has sent, or a recall letter in the SURFACE Act the bank has sent. And after that recall letter, no amounts have come from the company into the bank accounts, and the debt is still due. In such cases, normally NCLT gives an notice to the corporate debtor, the company. They are allowed to file their reply. The company has a very limited defense that they can take, that the company has already paid off the debt and evidence to support that same. This is the only limited defense to in that. There are many defenses that the companies take, but long and short, this defense is the primary defense that they can take. If that is not proved, if the debt is still outstanding, the NCLT proceeds to admit the petition and necessary and CIRP is initiated. This is about now section. This is all we have discussed about section 7. Now, if I may show you about section 9. So we are on the first page of this. Section 9, as I said, what is section 9? Section 9 is everything about operational debt. Section 7 was financial debt. Section 9 is now operational debt completely. When a company has availed any goods and services and the company has defaulted in making payments of those goods and services, the company has an option, defaulted in payment of goods and services. The creditor who has provided that goods and services and who was supposed to receive money does not receive the money. The creditor has an option to go to NCLT and file an application under section 9 and say that, look, I have provided goods and services. The goods and services have been taken, necessary invoices have been raised. There is no dispute in respect of those goods and services. And now please, an amount more than 1 crore has to be recovered by me. The company is not paying me that 1 crore and more. And now please initiate insolvency against the corporate, against the company. So as we said in section 7, there were two ingredients which NCLT regularly sees. In section 9, there are 3 ingredients in that sense. 1, there has to be a debt in relation to goods and services. Second, there has to be a default in repayment of that debt. And third, there cannot be any pre-existing dispute in relation to that debt. If there is any pre-existing dispute, that issue becomes a triable issue, and then NCLT ought to reject that application, generally rejects that application. These are the 3 ingredients which a creditor has to satisfy NCLT. Now let's go to section 9. Before filing a section 9, you have to, I deliberately took you to section 9 first to show what section 8 means. So before you file an application under section 9, the operational creditor has to issue a demand notice. This is a statutory demand notice to the company, say recalling the debt and giving the company a sufficient time of 10 days to repay the debt. In case if debt is not repaid by that company, the cause of action arises. Unless section 8 notice is issued by the creditor, the occasion for filing a section 9 never arises. So this section 8 is a prerequisite. You guys must have dealt 138 matters where there is a statutory notice which has to be issued, and the creditor and the holder and the person who has signed the check was given a period of 30 days, and the payment is not made, then only the cause of action arises and the occasion to file an complaint under 138 is there. Similarly, this is a statutory notice which the creditor has to give under section 10. So first let's see section 8, sorry. So section 8 says an operational creditor may, on the occurrence of a default, deliver a demand notice of unpaid operational debtor, copy of an invoice demand along with a copy of the invoice demanding payment of the amount involved in the default to the cooperator in such form and manner as may be prescribed. So the format of a section 8 notice is again prescribed. Prescribed by whom? Again in the rules, application to adjudicating authority rules, as I showed you. I'll take you to the format as well of the section 8 notice. Point number 2, the cooperator shall within a period of 10 days of the receipt of the demand notice under subsection 1 bring to the notice of the operational creditor existence of dispute and record of pendency of suit or arbitration proceedings filed before the before receipt of such notice in relation to dispute or the unpaid operational debt, the unpaid operational debt by sending an attested copy of the records of the electronic transfer, by sending an attested copy of the record of the operational creditor as an encashed check issued by the operational debtor. For the purposes of this section, a demand notice means notice served by the operational creditor to the operator demanding repayment of the operational debt in respect of the debt default that has occurred. So what this section 8 says? Section 8 says the operational creditor has to issue a demand notice under section as may be prescribed under what? Under the adjudicating authority rules. And the demand notice requires the company to make repayment within 10 days. If the company does not make repayment within 10 days, the corporate debtor has to reply to that demand notice within 10 days. And what does the corporate debtor has to reply? Saying that there is an existence of dispute. That dispute has to be shown by some record, or if there is any suit or arbitration proceedings which is filed in respect of that, or the corporate debtor should come up with documents to show that there is no debt which is to be repaid, because I have already repaid that debt, and evidences are to be provided in respect of when the debt was repaid. So this is notice of dispute, as we say, that the corporate debtor gives to the creditor. So once the demand notice is sent, there are two situations that arises. Either the corporate debtor has replied to your demand notice and disputed the debt or provided the evidences that he has prepaid the debt, or if he has not replied to that demand notice. In any eventuality, the operational creditor, after expiry of 10 days, gets a entitlement to file an application under section 9. So this is an application under section 9. After the expiry of the period of 10 days from the date of delivery of the notice or invoice demanding payment under subsection 1, subsection 8, if the operational creditor does not receive a payment from the corporate debtor or notice of dispute under section 2 of section 8, the operational creditor may file an application before the adjudicating authority for insolvency resolution process. Now, the operational creditor will file an application. The application under subsection 1 shall be filed in such manner as may be accompanied and as may be prescribed. Now, prescribed under what? Again, in the under insolvency and bankruptcy application to adjudicating rules. The format is given here. I'll take you to that format. The operational creditor shall, along with the application, furnish the copy of invoice. Now, this is very important. This is something which are prerequisites to file a section 9. The section 9 should always be accompanied with this. What are those documents which have to be filed along with section 9? A copy of invoice demanding payment or demand notice delivered to the operational creditor to the corporate debtor under section 8. An affidavit to that effect that there is no notice given by corporate debtor and relating to a dispute of the unpaid debt. This is triggered when the corporate debtor does not reply to your demand notice. This is generally under section 9(3)(b). It's an affidavit under 9(3)(b) as we call. And a copy of certificate from the financial institutions maintaining accounts of the operational creditor confirming that there is no payment of an unpaid operational debt by the corporate debtor available. These are generally bank statements. Bank statements to what effect? Saying that I have sent a notice under section 8. The corporate debtor has not made any payment to me within that 10 days or not replied to me within that 10 days. Here are my bank statements from that sending of that demand notice until now. See, I have not received any payments from the corporate debtor. This is the document that you have to provide to NCLT. Again, a copy of record of information utility. I have told you what information utility is. Similarly, as you did in section 7, we have to, the creditor under section 9 also has to inform to information utility that there is a debt which has been there is a default which has been occurred in respect of a debt. That proof has to be attached here, and any other proof confirming that no payment has been received. This can be your ledger account. This can be anything else. This can be an acknowledgement by the corporate debtor saying that okay, I will pay you. Please wait for some time and all of that. Okay. Subsection 4. An operational creditor initiating a corporate insolvency resolution process under this section may propose a resolution professional to act as an interim resolution professional. Now, if you see the word may gives in discretion. It is not compulsory under section 9 to propose a name of the interim resolution professional. If you don't propose the name, the NCLT during the admission may appoint an IRP from the list of from the panel list that the IBBI has given. Section 5. The adjudicating authority shall within 14 days on the receipt of this application by an order admit the application and communicate such decision to the operational creditor and the corporate debtor if. Now the NCLT within 14 days has to do what? Admit the application. Generally, these 14 days are discretion, directory, not mandatory. There is a Supreme Court judgment to that effect. So eventually, the NCLT admits the application if following ingredients are satisfied. What are those ingredients? A. The application made under subsection 2 is complete. B. There is no payment of unpaid operational debt. C. The invoice or notice for payment of the corporate debtor has been delivered by the operational creditor. D. No notice of dispute has been received by the operational creditor and there is no record of dispute. E. There is no disciplinary proceedings proposed against the resolution professional. So now these are the 5 ingredients which have to the NCLT will consider and evaluate while admitting an application under section 9. If 5 ingredients are all satisfied, the application has to be admitted. The NCLT will otherwise reject an application. Why would the NCLT reject if these 5 ingredients are satisfied? The application made under subsection 2 is incomplete. Obviously, there has been payment of the unpaid operational debt within that 10 days, as I showed you from the demand notice. The creditor has not delivered the notice of dispute. The creditor has not delivered the invoice or notice of payment to the corporate debtor. D. Notice of dispute has been received by the operational creditor or there is a record of dispute in information utility. E. Any disciplinary proceedings is pending. So these are vice versa, these 2 actions. So you have to, while filing an application under section 9, you have to take care of all of these situations, that your application is complete and all of these situations are taken care of. This is very important. This is in that sense, before entering into the dispute or before entering into the merits of the matter, if this is not complied by you, then the application outrightly gets rejected. Okay. So once the corporate application is admitted, the corporate insolvency resolution process commences from the date of admission of the application. That is very obvious. Now, let's see what is the format of section 8 notice and what are precautions that you have to take while drafting a section 8 notice on behalf of the creditor. So this notice is again provided under rule 5. We'll go to rule 5 from here. If you guys can see, application, insolvency and bankruptcy application to adjudicating authority rules. This is rule 5. Just a minute, there's some problem. Yeah, this is rule 5. Rule 5 says demand notice by operational creditor, and operational creditor shall deliver to the corporate creditor the following documents, namely. So there are 2 ways of sending a demand notice. There are 2 formats: a demand notice in form 3 or a copy of invoice attached with a notice in form 4. It's very important to understand why these 2 formats are given. IBC could have simply given one format and said that this is the format you have to send the demand notice. But IBC has given 2 formats. Why? First, let's see form 3. Just a minute, there's some problem with the website. Okay, so form 3 is not being opening here. Uh, Let me verbally explain you what is the difference between form 3 and 4. Form 3 is very identical to the form 5 that I'll show you sometime later now. Form 3 and form 4, what is the difference? Supposingly supposingly the creditor has given the goods and services to the company, the corporate debtor, and the corporate debtor has, and there are some invoices which are raised in respect of that goods and services. And the company is defaulted in making payments of those goods and services. In that case, the creditor will have to send a notice in Form 4. And in Form 4, he will have to demand payment and attach that invoice which was raised. The attaching invoices is very important. Most people make mistake here. They send demand notices in Form 4. However, they do not attach the invoice, which in turn affects the maintainability of a Section 9 application. As you saw, that application becomes incomplete. This is a defense that generally corporate debtors take, so you'll have to be careful here. In case if there are some situations, for example, there was a contract which was entered between the operational creditor and the corporate debtor for providing certain goods and services. And under that contract, some advance was paid, or in that sense, certain amounts were were paid, and the goods and services were never provided by the corporate debtor, and that advance was also never refunded by the corporate debtor. In such cases, no invoices could be ever raised, right? So in such cases, demand notice is sent under Form 3. So what do we gather from here? In situations where the amounts are in relation to goods and services, but no invoices are raised in relation to that, a demand notice is sent under Form 3. Only if you send a demand notice in Form 3, the requirement for attaching invoice does not arise, provided there is no invoice which is raised. Are we clear with what is Form 3 and Form 4? Then afterwards, the demand notice or the copy of the invoice of demanding payment has to be delivered to the corporate debtor at the registered office by hand. These are the modes of service. You have to just take care of this, that this is complied. So this is all. This is about Rule 5 as to how a demand notice under Form 3 and Form 4 has to be sent and what precautions have to be taken. I will show a demand notice under Form 3 in the draft. So Section 8 we have taken care of. Section 9. Section 9 speaks about filing an application under Section 9 to NCLT by an operational creditor. What is the format in which the application under Section 9 is to be filed? It's provided under Rule 6, 8 and 9 of bankruptcy rules. Let's go to Rule 6 first. Rule 6, application by operational creditor. An operational creditor shall make an application for initiating corporate insolvency resolution process against corporate debtor under Section 9 in Form 5. If you guys recollect, under Section 7, that was Form 1. Under Section 8, that was Form 3 and 4. What is Form 2? Form 2 is consent of IRP. And this is Form 5 under Section 9. So any person who wants to initiate an CIRP under Section 9 has to file an application under Form 5. This is the specimen of Form 5. These are all amendments that IBC that have been made time and again. This website provides these amendments in grade, and you also get the date of the amendment, and you also get the notification if you click here. That is why this website is very helpful, and I prefer using this website. So Form 5, again, the format is more or less same. There is not much difference in the format. Part 1 is same, particulars of the applicant. Part 2 is same, particulars of the corporate debtor. Part 3, name of the resolution professional. Here you will see if it is, if proposed, it's not mandatory to provide the name of IRP. Part 4 is again details of debt, transactions, debt occurred, amount of default, on which the date on which the default occurred. Part 4 is same. Part 5, thereafterwards, particulars of security held in case if the debt is secured, record of default, succession certificate, contract or any other document, and the list of documents. So if you have seen, there is not much difference between Form 1 and Form 5. There is very slight differences that are there between both the forms. Then you will have to, these are same, the person has to sign it on their behalf, and we have to read these instructions. We have already discussed all of those instructions. What are the annexures which are required to be annexed with this document? Let us now go to an actual Section 9 application which has been filed. This was filed in 2022, a Section 9 application. The company was Sunrise Skating versus Oban Fashions. This application was admitted. We were the petitioners. Index, you will see in index similar to what we had filed in Section 7. Synopsis, list of dates, memo of parties, Form 5. After Form 5, all of those annexures which you are relying, documents. After documents, you have the general affidavit in Form 6. And after the general affidavit, an affidavit under 93B. What is affidavit under 93B? If you read Section 93B, we have already read that no reply, no notice of dispute was given by the corporate debtor to us. That is 93B. Wakalatnama, proof of payment of fees and proof of service. In this, the application fees are 2,000 rupees. For a Section 7 application, the fees are 25,000 rupees. So synopsis, as I said, you will have to narrate your short story. Synopsis should not be ideally more than 2 pages, as I have already said. Then the list of dates, all the list of dates you have to provide, memo of parties. Then your main application, Form 5. Form 5, the part 1 would be same. Part 2, details of the corporate debtor. Part 3, we have not we in that particular time had not proposed any insolvency professional's name, IRP's name. So we had said that it may be appointed by the NCLT. And then part 4 is what is total amount of debt granted. So and so was the total amount of debt. Details of the transaction on account of which debt fell due. So entire narration as to of the transaction, as to who was the applicant, how did the services were provided, in what manner services were provided, consumed, goods were consumed, uh, uh, invoices that were raised. Thereafterwards, any request that the operational creditor had made for making payment, the acknowledgements that the cooperator must have given, any confirmation of accounts that must have been exchanged, emails that must have been exchanged between the parties. Then the notice that you must have sent under Section 8 to the corporate debtor, whether there was a reply under the Section 8 notice. All of those details, the storyline has to be mentioned here. And once it is mentioned, all the documents are annexed. Likewise, you will say the date on which default occurred. So now, in this case, there are two types of accounts. Generally, the services are continuous. The supply of goods are in continuous form, and the creditor is making you payment invoice to invoice. The corporate debtor is making the payment to the creditor on invoice to invoice basis. Now, if that payment is made to invoice basis, every invoice will have a different date of default. So you will have to then annex a summary of date of defaults of the invoices, and you will say that the date of defaults are annexed, so and so. However, if the companies, the parties are maintaining a running account ledger, in that cases, the invoices, the last invoice which was raised will be your date on which debt fell due or the date of default. In cases where the running account is mentioned, for example, in first invoices of 1 lakh rupees, second invoices of 2 lakh rupees, third invoices of 5 lakh rupees, and the company has randomly made, the debtor has randomly made a payment of 10 lakh, say 2 lakh rupees or 1.5 lakh rupees. So on account payment, as we say. So this is called as running account ledger. In that running account ledger, your last date of invoice will be your last date of default. You must also make sure that any acknowledgements which have been given by the corporate debtor after you demanded payments, all of those acknowledgements, those correspondences are forming part of this petition. That will really help your case. Part 5 are, as you know, security certificate. Most of the things are not applicable. What provisions of law are you dealing with? Mostly it's Indian Contract Act, Insolvency Bankruptcy Code. However, if there is some other law applicable, you will also mention it there. Statement of account of the bank where deposits are made. Statement summary is annexed. And as I said, the list of documents you can also reiterate here. Here we have reiterated. What all documents have we relied upon while filing this application? One is copy of invoices. Second, copy of ledger account of the corporate debtor maintained in the books of the operational creditor. Third, copy of ledger account statement received by the corporate debtor through email return. So this is confirmation of accounts. Generally, parties have a practice of sending confirmation of accounts during the year end. So this is that confirmation of accounts. Fourth, demand notice that we had sent. 5 is bank account statement. Then, person authorized signing the form and his board resolution authorizing the person to sign the form. Then the list of documents that are sent that are next. After the list of documents, there is an affidavit, and after the affidavit, there is wakalat. I hope I am clear. So this is a format of filing a Section 9 application. So recapping very swiftly as to what precautions are to be taken while filing a Section 9 application. Section 9 application is filed in relation to goods and services by an operational creditor. For filing a Section 9 application, demand notice under Section 8 has to be sent. A 10-day period has to be given to the creditor, the corporate debtor. The corporate debtor has to respond within that 10 days. If the corporate debtor has, what can he respond to? Responding saying that there is a pre-existing dispute in relation to goods and services. What kind of pre-existing dispute he can raise? He can raise saying that the services that you were provided were not correct, and therefore I did not make you payment. This is the proof of our dispute before sending demand notice that we had done. Any evidence regarding any arbitration or suit, or he can also say that I have already made you the payment and this is the evidence of payment. After Section 8 notice is sent, Section 9 application is filed. Section 9 application, as I say, should contain all of those ingredients which the NCLT generally looks. Section 9 subsection 5 takes care of that. You'll have to see that properly. And along with Section 9, you have to attach all of this the documents which are provided in Section 9.3. We have already seen that. So these three requisites under Section 9 are debt, default, no pre-existing disputes. If these three ingredients are satisfied, NCLT goes ahead and admits the application. Similarly, I told you under Section 10. Under Section 10, also insolvency application can be filed. Who files the application? The corporate debtor itself files the application. The board of directors decide to file an application under Section 10, considering that they have defaulted in some cases and they cannot run the affairs of the corporate debtor. And now that it's better that the company, a corporate insolvency resolution process is conducted in respect of the company, and either they themselves, if they are MSME, or someone else will take this company ahead. So how do you file a Section 10 application? A corporate debtor has committed a default, a corporate applicant. So corporate debtor here in Section 10 is called as corporate applicant. Only in Section 10, if the corporate debtor files an application, he is called as corporate applicant, nowhere else. Otherwise, he is referred to as corporate debtor. So where a corporate debtor has a committed default, the corporate applicant thereof may file an application for initiating corporate insolvency resolution process with adjudicating authority. The application under subsection 1 shall be filled in form containing such particulars and manner as accompanied as may be prescribed. Again, where prescribed? Rules 7, 8, and 9. The corporate applicant along with the applicant furnish the so and so. So they will provide, sumoto provide this copies to the NCLT. Now what documents will he rely? He will rely upon those documents to show that he himself is defaulted. The company itself is defaulted in payment of loan. So the information relating to books of accounts of the of documents as may be specified. Information relating to the resolution professional to be appointed. A name has to be appointed mandatorily, proposed mandatorily. The special resolution passed by shareholders of the corporator or the resolution passed by 3/4 of total number of partners of the corporator as case may be, approving filing of this application. So what is the prerequisite for filing a Section 10? The shareholders of that company should pass a special resolution saying that okay, you file an application under Section 10 before NCLT. Adjudicating authority, I have said that this 14 days period is not mandatory. Shall, after receipt of the application by an order, admit the application if the application is complete, one requirement, and second condition, that there is no disciplinary proceeding filing pending against the IRP, or reject the application if the application is incomplete, or no disciplinary proceeding or any disciplinary proceeding is pending against the IRP. Provided that a adjudicating authority shall, before rejecting an application, give a notice to the applicant to rectify its defect. So, supposingly in the application, and there is some defect which is there, say in that sense, uh, for consent of IRP is not attached, or there is some typo error, or the date of default is incorrect. All of that defects can be rectified. Those are rectifiable defects. The NCLT, before dismissing the application, will give an opportunity to rectify these effects within 7 days. And thereafter, the corporate insolvency resolution process can commence. Then Section 10A, we have already discussed about Section 10A. No applications under Section 7, 9, and 10 can be filed during this 10A period. That period was 1 year from 27th March 2020. Okay. So no defaults arise during this period, the applications can be filed. The applications have been filed between this period, but the defaults were prior to that period. So any default that has commenced during this period, no applications could have been filed. So this is section 7, 9, and 10 we have seen. Let us also see how section 10 application looks. Let's go to Rule 7 of Adjudicating Authority Rules. Application by corporate applicant. Application by corporate applicant. Corporate applicant may make an application for initiating the corporate insolvency resolution process against the corporate debtor under section 10 of the code in form 6. What was the earlier section 5 was form 1. Sorry, so earlier section 7 was in form 1. Section 9 was in form 5. Now this section 10 is in form 6. Don't get confused. It's very simple. Write it down. Make your notes. Form 6 looks in such manner. Form 6. Again, part 1. Same details. Part 2. Part 3. Oh, there are only 3 parts in this form. Part 1 is name and address of the corporate applicant. Corporate applicant is the corporate debtor. Part 2, name and address of the IRP. Part 3, name of financial/operational creditors. So in respect of whom you have defaulted, that details has to be provided. Addresses of those financial creditors, the details of debt, and the security that is held. So in these 3 parts, this form is taken care of, and all of those applications and all of those documents which evidence your default has to be annexed. These are less, section 10 are the very less frequent applications that are filed. Generally, major applications that are filed are section 7, and after previously before that 1 crore threshold, section 9 used to take a lot of weightage in the number of applications, but after that 1 crore limit, section 9 applications have considerably reduced for obvious reasons, because no single creditor who provides goods and service will provide a credit of 1 crore and more. Therefore, generally section 7 and 9 applications are filed. So all of this, after filing these applications, as I said, if the NCLT is of the opinion that there is a debt, there is a default, there is no pre-existing dispute, there is the record of default in the information utility, there are no disciplinary proceedings, the applications are complete in proper form, prescribed manner, fees are paid, all of these check boxes are ticked, NCLT proceeds and admits the application. So I think we have discussed in details what precautions we have to take, what are these applications, or what precautions we have to take while filing all of these 3 applications. After filing of these 3 applications, NCLT proceeds and admits the petition. After admission, necessary CIRP starts and necessary consequences necessary consequences takes place. I am sure you guys must be aware about what are the consequences that takes place after initiation of CIRP. So I was supposed to initially complete both the topics, that is filing of liquidation petitions and insolvency petition in the same seminar. But I think this seminar itself has taken 1 hour 15 minutes. It's become a lengthy seminar. Therefore, it's preferable that we discuss about the liquidation petition, liquidation application in the next seminar. So I think we have discussed in detail, and in case of any queries, I will my email ID is aand and glegal@gmail.com. You can post your queries, and I'll make my endeavors to revert to your queries. Okay, thanks a lot, guys.